Okay. Take it easy. Yeah, thank you.
All right. This honorable board is now in session. Please be seated.
Good afternoon. Welcome to this second afternoon case here in the June docket for the Tennessee Court of Criminal Appeals Western Section in Jackson, Tennessee. We're delighted you're here. We are going through the protocols and with each panel because we are not all together where we can say it one time and everybody hears it. So each time we have a new group of participants come in, we try to at least educate them on what's going on and hopefully get your input at some particular point in time. Welcome. This morning we have decided as a court months ago that we always have been open. We have always been working through the COVID pandemic, and we wanted to continue to do so, but we wanted to grant the general public, the media, and interested parties greater access to our court and our procedures than there's ever been. We've sought that in two ways. One, you can come see us. You can sit right in the courtroom and watch us as you've always been allowed to. Two, you can tune into YouTube, which I know very little about, but I understand works pretty good. And you can watch us live stream on that. Or three, you can use your telephone and call in a specified number that will be given to you by the clerk's office, and you can listen live in real time there. A greater access has never been given by any courts in the state of Tennessee. We're very proud to lead with that. There's also a few other little protocols that have changed, how we enter the buildings, how we exit the buildings. We appreciate the very much cooperation from all the attorneys that have to enter. It is for your safety and the safety of others that work in the building. We do this. If you see lapse in that, please let us know. We'll try to fill those. Other than that, it's pretty much the same, except you are allowed to stay at your seats. We do not require you to come to the podium. You do not have to wear a mask, but you can if you wish. You do not have to stand unless you wish to stand. General Cherry, some of us that are around our age have found the farther we get from our notes, the harder they are to see. And without a podium, so sitting has been the preferred manner, and that's perfectly acceptable. We see no disrespect to that. Each side has 20 minutes. If you wish to reserve any time for the rebuttal, please do so upon approaching the well. And one of the most enjoyable jobs I have is introducing the panel who I have the honor to serve with today. And to my left, Judge Ross Dyer from Memphis, Tennessee. To my right, Judge Camille McMullen, also from Memphis, Tennessee. I'm John Everett Williams, up the road here in Huntington, Tennessee. With that, Mr. Clerk, could you call the third case?
Felix Hall versus State of Tennessee.
Yes, sir.
Should I come up?
No, sir, just right where you are. We're fine.
And I was told that sitting or standing is okay.
Yes, sir.
Does anyone prefer if I wear a mask or have any concern about that.
All up to you, sir. We're far enough away. I don't fear you.
I'm not gonna, I don't think I'm gonna send any germs that far. Good afternoon, your honors, and may it please the court. Felix Hall is petitioning the court to reverse and remand his conviction for today for 3 reasons. The first 2 reasons both deal with Mr. Hall's right to remain silent. He was initially asked questions at the scene where he was arrested by an officer, and at trial, the state's attorney commented several times on his failure to make any statement to the police officer at the time of his arrest. The second issue, and at trial, his defense attorney failed to object to the state's comment on Mr. Hall's silence. The second issue is that Mr. Hall was pressured to testify by his attorney, and that because of that, he did not make a knowing and voluntary waiver of his right to remain silent at trial. The attorney's statements in the Moman hearing pressured Mr. Hall unduly. The third issue that we raise is that Mr. Hall's attorney failed to object to several photos, to a pair of photos, which showed several items in the cab of the truck: drugs or drug paraphernalia and ammunition. The attorney's failure to object to those photos, which had no bearing on whether or not Mr. Hall had committed the crimes for which he was charged, all 3 of those failures by the attorney, the defense attorney at trial, represent ineffective assistance of counsel, and we'd ask that you overturn for those reasons.
Counsel, if you don't mind, we are operating under new criteria these days, and you know that each one of the members of the court have read the files, and we're very familiar with this case. But do you mind if I attempt to try to, at least for somebody that might be listening and not know, you are bringing an appeal from a denial of a post-conviction relief petition?
Yes, I apologize.
This gentleman has already been, no apologies necessary. See, I may owe you the apology when I get through talking. So see if I've accurately got you where you want to be. He has been found guilty in front of a jury. After the jury trial, he has alleged that his trial counsel did not do virtually 3 things that they should have done. You have had a trial on that, and the trial court ruled against you. It said that there was no ineffective assistance of counsel and no error that would result in granting a new trial or new relief in this, and you are appealing that decision to us. You have the burden in this case to convince us that there was ineffective assistance of counsel by clear and convincing evidence on each of the 3 items that you have talked about. Is that correct?
That is correct.
I hope I succinctly.
Appreciate that. The only slight amendment I would make to that is that I was not Mr. Hall's attorney when his case was initially presented. His post-conviction petition was presented to the trial court.
Yes.
You took over on appeal?
But yes, but Mr. Hall, appeal of the post-conviction denial. But Mr. Hall, I was appointed to Mr. Hall to represent him in this court. If I can move to the first issue, which I think is the most egregious error by the trial defense attorney, the failure to object to the state's persistent, and I should have also mentioned this at the beginning. I'd like to reserve 5 minutes of my time for.
I'll try to keep up with it for you.
The first issue is Mr. Hall's, the state's attorney's repeated commentary on Mr. Hall's failure to make a statement to the arresting police officer. Mr. Hall was arrested in a vehicle that was stolen. It was not recently stolen it was stolen about somewhere between 2 weeks and 19 days before he was arrested in that vehicle.
Why did I get the impression that he had recent possession based on the status of the chicken found in the truck?
There's 2 separate crimes alleged,
Okay.
two separate incidents, and evidence of both was recovered at the time that he was arrested. He's stolen a tractor trailer cab, and then he's alleged to have used that tractor trailer cab in a burglary of a Wendy's that happened the morning that he was arrested. So
Okay.
the vehicle had been missing for a substantial period of
I
time.
understand.
The chicken had only been missing for a few hours.
Okay.
And there is some dispute and some factual dispute about whether that chicken was actually the chicken that was taken in that burglary.
But that has been decided against you.
In the trial
That-
court,
that
yes,
issue.
yes. So the state repeated that it's true that under some very limited circumstances, a prosecutor is allowed to ask a defendant about whether they made a statement to police. But those circumstances are extremely limited because of the primacy of the defendant's right to remain silent. And the only time that a prosecutor can make any comment at all on a defendant's failure to make a statement to police is when the defense opens the door to that testimony by claiming that essentially by claiming that the defendant did make a statement at the time of the arrest.
Or giving the impression that they indeed cooperated with the police at the time of the offense.
And in this case, the defendant's testimony, while it was self-serving, did not at any point suggest that he had made any statement to the police.
Well, I thought there were, okay. I'm going to let you finish your facts because I got the impression that his testimony was he told the police that the person who either stole the tractor or truck or whatever it was in the hotel. And that was what was really being disputed.
Well, his testimony at trial was that there was a third party who had actually stolen the vehicle and loaned the vehicle to him.
Okay. Clarify for me this. Was that his testimony during the Momen hearing to determine whether he was going to testify?
That was his testimony to the jury after the Momen hearing.
Okay, well, during the Momen hearing, because I'm getting confused about when he said that the woman who was at the scene actually was the person who said, or who gave the police the statement about the other party who was alleged to be responsible in this case.
He testified to the jury that the woman who was in the passenger in the vehicle told him, his testimony could have easily been objected to as hearsay. What he said was,
Okay, that's what I'm getting to.
the woman in my passenger seat told me, they separated the two individuals in the truck. And he said that later on, she told him that when they were both separated and talking to the police, she had explained to the police
All right.
why he was in possession of a stolen vehicle.
And did he clarify that when the state started asking him about that in cross-examination, or did he just answer affirmatively that he told the police, or he tried to tell the police that there was a third-party suspect?
In cross-examination, the prosecutor specifically asked him the question that the prosecutor is not allowed to ask unless the defense
Unless the
attorney
impression
opens
is given that they in fact cooperated with the police at the time of the offense.
Exactly. She asked him, I'll try to get to the exact language.
Can you circumvent the rule by saying that it was someone else who said it? You understand what I'm getting
Yeah,
at? Because I
yes.
got the impression from the briefs and a partial reading of the, I guess, the order or the transcript in this case, that the defense was trying to narrowly tailor what he was going to say in anticipation of the state asking this question.
That's, I guess that's a conceivable, I guess that's a possible interpretation, but I don't think that under the case law that, I mean, the case law is pretty clear that this carve out where you allow a certain very small subset of cases, you allow the prosecutor to comment on whether the defendant made a statement. That rule is supposed to be very narrowly construed. And he did not say that he had told the police anything. So it's not impeaching anything that he said.
So assuming that you're right, okay? So what your client said was that somebody else told the police that there was a third party suspect.
That's right.
And that's supposed to be allowed.
Yes.
So he's still giving the impression that there was cooperation with the police, that there was a third party or there was a third party responsible for the crime and not them at the time, right?
Yeah.
So he's cloaking himself with hearsay that somebody else
Well,
told the police.
and that was not objected to by the state at trial. I think the evidence could have never come in if there had been an objection to it. But once he begins testifying that way, I think that the state is either stuck with the testimony that he gives. Once they allow that testimony without objecting to it, they're allowing him to cloak himself in that way. And I don't
I'm going
think.
to stop asking you questions in just a second. So is the rule, I don't know if it's Doyle or whatever, just on post-arrest silence, is it so narrow that it has to be the defendant giving a statement? Or is it a little broader by saying the defendant trying to give the impression? That's my read of this body of law. You know, if the defendant is trying to give the impression that he somehow cooperated with the police, you know, at the time of the investigation, the state has a right to rebut that impression. And that's when you get into this discussion about post-arrest silence. Is that fair?
I think that the language is, they said, the U.S. v. Robinson opinion says that the state can raise it as a fair response after the defendant provides that or gives that testimony. I don't think there was a response to his claim. I mean, I think the appropriate method for the state to use, if someone's going to offer that kind of testimony where they're cloaking themselves through a third party hearsay testimony, the first thing you can do is object because it's hearsay. And then you can argue in closing that he gave this bogus story about this woman because he didn't want, but why should you believe anything that she said? She's not here. We can't cross-examine her. Those are all legal arguments that don't violate a constitutional prohibition. But instead, the state's entire approach to this case was to attack the credibility, the defendant, Mr. Hall's credibility. That was their whole game plan. There are comments.
That's what happens sometimes in trial.
And they shouldn't, I don't think that the state should be allowed to choose to violate Mr. Hall's constitutional rights rather than to make a hearsay objection.
We're getting into your rebuttal time, believe it or not.
Oh, I'll stop there.
You want to take another minute?
I'll stop there.
Okay. General?
May it please the court, Brent Cherry for the state. I feel kind of funny sitting here instead of standing. And I think if I stand up, I'll be too far away from my notes, even with my glasses. So I appreciate these accommodations. This case is reminiscent to me of a number of cases I handled many years ago when I was a young defense counsel, when I'd get clients who would come in, and in the practice where I was operating in the Marine Corps, we usually had the case filed before us before we ever met with our client. We were able to look through the statements and the evidence, and then the client would come in, we'd sit down with them, and we'd talk about a strategy. And oftentimes, if the evidence was too compelling, the first process would be to think about at least a possible plea, because in our estimation, oftentimes there was just no way we were going to win this case. We had no valid defense. And this is very reminiscent of a case, of that type of case. In May 2012, the petitioner was stopped while driving a stolen Freightliner tractor truck. In the truck's cab, police found a box of partially frozen chicken breast and a box labeled Wendy's, and police learned that a Wendy's restaurant had been burglarized just hours earlier. The petitioner was ultimately charged with and convicted for the theft of the truck, burglary of the Wendy's restaurant, and the theft of the chicken breast. On post-conviction, the petitioner argued that counsel provided ineffective assistance at trial, and the post-conviction court denied relief, and now the petitioner appeals, and that's what brings us here today. When we look at this case, again, the question is, did Mr. Johnson uphold his duty to provide effective assistance to the counsel, to his client? The defense in this case was simply, I thought this was my friend's truck, and he was just letting me borrow it. And another part of the petitioner's defense was that he told police about his friend right after they stopped him, and he told them about the American Inn Hotel where his friend was staying, but the police failed to investigate. So he was setting up a defense, trying to tell the jury that, hey, I'm an innocent guy, I was just driving my friend's truck, and I did cooperate with police. Now, the way this came out was kind of funny. The petitioner was in a tough spot. There was no way to get this story out unless he told it. The woman he had been with that night was not there. His friend that had been staying at the American Hotel was not there. The only way that story was going to get out was if the petitioner told it. Now, Mr. Johnson, as he was talking about this with his client, he told him, you're going to get convicted unless we put up a defense. And even if you put up this defense, you still may get convicted, but it's all we got. You got nothing to lose. Now, as far as the post-arrest silence is concerned, petitioner complains that counsel was ineffective because he failed to object, and the state commented on his post-arrest silence. But again, according to the petitioner, he told police that the truck he was driving on the night of arrest belonged to another man, and he told them where to find the man, but they failed to investigate. If we look at Mr. Johnson's cross-examination of the police officers at trial, we see that he was laying a foundation for the claim that the petitioner told police about his friend at the hotel. On direct, Memphis police officer Hardy Savage testified that he stopped the petitioner in the stolen truck. He found a cut lock. It isn't really clear, at least from my reading of the transcript, whether that lock was from the Wendy's or from the site where the truck had been stolen, but there was a cut lock in any event. And there was also a pair of bolt cutters and the partially frozen chicken. Officer Johnson also testified that a white female was in the truck with the petitioner at the time of the stop. Now, during cross-examination, the petitioner's counsel asked Officer Savage whether the petitioner or his female passenger had said anything about a hotel during the stop. So right there, he was focusing on what did the petitioner tell police. Officer Savage did not recall whether the petitioner or the woman said anything about a hotel. Later, Detective James Harden testified about his investigation of the case, and he was asked during his cross-examination whether he spoke with the defendant or the woman who was with him that night. He testified that he did. Mr. Johnson then asked whether, as a result of speaking with them, did he ever do an investigation at the American Inn? Again, we see this setup of trying to persuade the jury that the petitioner was cooperating, that he was talking to police, and that they should have followed up on what the petitioner told them by going to the American Inn and finding Mr. Davis, who was the person who took the truck. Detective Harden, however, denied that anyone gave him any information that would have caused him to investigate anything at any hotel. After the state concluded its presentation of evidence, the petitioner chose to testify, and during voir dire, he affirmed that there were statements that he made to police that didn't come out during the officer's testimony. His position was that the police denied that the petitioner ever said anything, when in fact, the petitioner told them all about his friend Eric Davis and where he could be found.
Did he explicitly say during that hearing, and this, we're talking about the moment hearing, right?
Yes,
And did he explicitly say at that hearing that he told the police that his friend was at the hotel?
he did not go so far at the moment hearing, but what he did tell the court was, I want to testify because there are things that I told police that need to come out. Now, during his testimony,
I'm sorry, I want to be clear on this point. Things he told the police that he wants to come out, or things that were told to police? You see the distinction I'm making there?
yes,
Okay.
yes, I do see that, Your Honor, and I believe he said things that I told the police.
He told the police. Okay.
During his testimony at trial, the petitioner explained that to his knowledge, the truck belonged to his friend, Mr. Davis, who allowed him to drive it on the night of his arrest. On direct examination, the petitioner testified that Sherry Hutchison, the woman who was with him, quote, mentioned to one of the officers that Mr. Davis was in the American Inn, unquote, but did not investigate. Now, I need to clarify, I did have a misstatement in my brief. It was not on his direct testimony that the petitioner said that he told police. He didn't come out that far. It was during the cross-examination, and I apologize for that misstatement in my brief.
So on his direct, he just mentions the lady saying something telling him that she told police something.
That's right, yes. Your Honor.
Then on cross, when questioned by the state, is when he says he told police something.
Right, yes, Your Honor.
Okay.
So we get into cross-examination. The state asked the petitioner whether he gave any information to police after he was stopped. It was not an improper comment on the petitioner's right to remain silent, first because the petitioner's position was that he did not remain silent. He waived that right when he proclaimed that he had talked to police and given them a statement.
But he didn't.
He didn't. Yeah, go ahead, you're on it.
From what I'm understanding you to say, and he didn't say that. He did not testify to that during direct.
He did during cross. You're right, Your Honor. This is what makes this.
Cross is off limits. Cross is a response to what he said on direct, right?
Well, that raises an interesting question, Your Honor. And here's the reason that becomes interesting. If on cross-examination he had said, no, I chose not to make a statement because I was relying on my right to remain silent, then we have a clear violation.
That's not going to happen. You and I both, we know that's not going to happen, okay? The state's not going to say that on cross-examination for fear of commenting on his right to remain silent, only in response to an impression that he's trying to claim that he cooperated, and I'm losing the precise words, but an impression that he had cooperated at the time. Does the state have the right to come in and then rebut that by commenting that he did not? So I'm understanding you to say that didn't exactly happen in this case.
Well, here's how the impression arose, Your Honor. First of all, the way Mr. Johnson approached this case by questioning the officers and trying to draw from them that the petitioner did make a statement and did tell them about this man who actually stole the truck. He was trying to establish
But the question,
this pattern.
but the questions by counsel are, especially defense counsel, that's fair game. I mean, it is, hey, if nothing else, I got nothing else, so let me throw a rabbit in the jury box and see what happens. Those questions, no one challenges the legality of defense counsel at least trying to plant a seed in the jury's head that, hey, there may be another theory out there. Then when the defendant takes the stand and says, oh, by the way, the woman I was with told me that she told the police X.
Without objection from the state?
Without objection, without objection from the state. And then the state turns around on cross and changes the narrative, because the state turns around and cross says, what did you tell police? He never said he told police anything.
Yeah, the state I think you would agree with me that the cross-examination was very aggressive on the fact that he didn't cooperate with the police. And then he responded he did. That was what the impression that I got. This prosecutor just narrowed in and nailed him down on the fact that, was it you that told the police? And he said, basically it was me. I told the police at the time that my buddy was the one responsible, and he's over in the American Inn Hotel. And she kept on down that very, and then weaved it through closing and everything else. So my problem is, my first problem was, did he have the right to cloak himself with someone else's statements? Clearly, I don't think he had that right to do that and still put, say I can stand on my Fifth Amendment right to remain silent, or my Miranda rights. But what I'm hearing you say now factually is he never said that. He never said that on direct in front of the jury.
That's right. But here's an important part of this whole equation that we have to remember. What we're talking about here is the performance of Mr. Johnson, the defense counsel. What was his theory of the case? The theory of his case, the theory of the defense was that this other guy took the truck and that the petitioner cooperated and tried to tell police what was going on so they could find out that he wasn't the thief here. Mr. Johnson's performance.
Claim, a constitutional claim. Is this just couched in the ineffective assistance? I thought it was a standalone claim as well.
This is an ineffective assistance of counsel claim on Mr. Johnson. Okay. So Mr. Johnson, he sees this developing. He wants this to come out. The only shot he has, if he brings out the fact that this other guy drove the truck, and then the petitioner's claiming in addition that he cooperated, that he told police about this on the night that he was arrested. That's the position of the defense. The only way to get it out is through him.
I'm with you, Mr. Cherry, but I'm going back to what I questioned Mr. Israel about. Mr. Johnson is a 25-year public defender. He was very calculated on what he was trying to do in this case. It was very calculated from my impression of my recall of his testimony that he did not want his client to open the door on this issue. They were very well aware of what was going on at trial. If he said that he was the one who told the police rather than the girlfriend. And so that, in my mind, lets me know that he was aware of what was going on, and it cuts against the state's argument in this case that this should be, I guess, not ineffective assistance, or this was assistance, this was effective assistance. Does that make sense? What I'm saying?
I think it does, Your Honor.
Counsel knew where the line was.
Yeah.
And he was trying every bit of he could to stay on the correct side of the line, which I think this is your point. As soon as they crossed the line, he should have been jumping out of his chair objecting, because that was his strategy, was to try to stay on the left-hand side of the line. And as soon as they got to the right-hand side of the line, he should have been objecting, because he was walking that tightrope, and then he didn't. So, I mean,
and I think if he conceded as much that he should have been objecting. I don't know in so much as to I remember he said that he should have objected. I don't think he testified during the PC hearing in terms of, how this was prejudice, and maybe you could speak to that, how this, I do believe this was extremely prejudicial to his case, but maybe the state wants to weigh in on it.
Well, Your Honor, I think the prejudice is, and we can talk about that certainly. I mean, I don't think that it wouldn't have made a difference. He was right there. He still had all this evidence against him, and it didn't change that. The fact that Mr. Johnson, now maybe he was trying to walk a fine line. He kind of got under the wire by getting this hearsay out that Sherry Hutchison said something to police about something at the American Inn, but that really didn't get the whole story out. And when the petitioner had the opportunity, he jumped on this like, well, I can't think of a good example of what he got onto it like stink on a skunk, but he was after it. He was like, hey, I told police.
But he was after it after the state asked the question.
But he was also giving a premonition of this during voir dire. Now, obviously, it's not before the jury, but he's telling the judge, hey, there are things that I said that should have come out, and they didn't come out. So his whole position, the petitioner's testimony was that I told them right from the start. Now, how can you have a petitioner relying on his right to remain silent when he says he didn't rely on his right to remain silent?
Yeah, I mean, I get your position that, you know, we don't need to let defendants just sit in the weeds and all of a sudden spring these great ideas on the jury and everybody else at trial. But I guess my concern is, you know, what he said in voir dire during his moment hearing has some weight, but not really, because the jury never heard that. And what the jury did hear is, hey, you kept your mouth shut until it was the opportune time for you to speak. And the only reason they heard that was because the state asked the question, not because his attorney asked him what happened that night. And he said, oh, I told the police this, because what he said is, well, she told me that she told the police that. And I go back to the point Judge McMullen made at the very beginning. I don't know if you can cloak yourself in that anyway, but, you know, it seems to me that his specific right and whether he said something was only opened because the state opened the door. So I think whether it's deficient or not, you know, I don't know, because again, I think it goes back to whether you can cloak yourself in this. I think the question that best to be answered is, did it matter? Was it prejudicial?
Well, just one last point on the ineffective assistance part. Mr. Johnson, once this testimony comes out, now he could have objected and say, I don't want my client to be prejudiced because he relied on his right to remain silent, even though he says he didn't rely on his right to remain silent. And he's kind of caught in a difficult spot there when he wants to argue that there was a right to remain silent, but the petitioner said there wasn't. How does he deal with that? Is it best to raise that issue at that point, or is it better to just let the petitioner tell his story and hope that the jury believes it, or that they have some reasonable doubt about the circumstances of this case based on the petitioner's testimony? Now, if we move on to the prejudice part of this, is it going to make a difference? Now, the best case scenario for the petitioner would have been that the police had gone out and investigate and they bring in some evidence that, yeah, there was an Eric Davis there and there's some corroboration. After the petitioner testified, the court broke for the night and they came back the next morning. Overnight, the state ran out to the hotel. They brought in the manager who scoured his records. He didn't find any record of any Eric Davis or Sherry Hutchison being at the hotel. Now, did somebody else rent the room and they stayed there? It could be, but there was no evidence to support that. And they jumped through those hoops trying to establish as much as they could whether there was any credibility there.
Were the records at the time of the offense, were those the records that were evaluated and testified to? Did I read somewhere that these were records that didn't pertain to the time of the offense?
Well, the manager said that he went back and looked at the records and he couldn't find anything from that time.
The time frame was looking
Right,
like.
right.
So we don't know whether the manager looked at when did this happen?
Oh, it was in May of 2012. So it was a while back that this all happened. So, but you know, the state was trying to jump through hoops to present whatever they could and follow up on this after the fact. Now, as far as prejudice is concerned, did it hurt the petitioner that he said, hey, I told police about this? Did it hurt him in his whole theory of the case? If he had not said anything about that, if all the state had was he was in the truck, he had the chicken, the truck was obviously stolen, the chicken were obviously stolen, he has no story to support him except Sherry Hutchison said something about a guy at the American Inn. And if we stop right there, what happens to the case? The petitioner is still convicted. He still goes to jail. The fact that he got out his story that he told somebody about this, and you know, the police that he relied on his right to remain silent, although he said that he didn't. Does that change the outcome of the case? And the answer is no, it doesn't, not in any
I
way.
guess it's not that simple, because it goes back to what Mr. Israel was saying in terms of you're talking about the credibility of the defendant when he gets up there and he's saying the state's giving the jury the impression that he saved this story till it was convenient for him to use.
Yeah, I mean, I
So
think the
that's-
prejudice argument makes more sense or is better suited if the defendant doesn't testify. But once the defendant testifies and they bring in his credibility, that's where the problem comes.
And that takes us to the second point, the second claim of ineffective assistance. Mr. Johnson encouraged the petitioner to testify. Now, was that a bad move? The petitioner's story was the only defense they had. It might not have been a real good defense, but it was a defense, and it was the only one they had. He doesn't talk, he's going to go to jail. If he talks, he still might go to jail, but maybe there's a chance. So is that ineffective assistance? That's a strategic decision, and it's pretty hard to look back and say that it was a bad decision. Now, let's talk for a minute about the photograph. A photograph of the inside of the cab.
Let's talk for 1 minute about it.
I'll try to make it real short, Your Honor. And I think I've explained this in my brief, but the photograph, there are a couple of photographs of the inside of the cab, and you can see in the photograph there are different types of ammunition. There's some boxes of 7.62. That's typically the kind of ammunition that's used in an AK-47, a little bit heavier round than a typical AR-15. And then there were also a number of pistol rounds, but there's no weapon. We're not talking about a case where we had any kind of violence associated with this crime. So could Mr. Johnson have objected? Yeah. Did it make a difference? Would it have made a difference? No. And as far as a cracked pipe is concerned, I studied those photographs pretty carefully, trying to see where the cracked pipe was, and I couldn't find it. I think I'm fairly well versed in recognizing paraphernalia from evidence, and I just couldn't see it. There was no comment made at trial about the paraphernalia. There was just a quick comment about there's some ammunition that was found in the truck, and that's it. So did the petitioner get effective assistance of counsel? I would assert very strongly that yes, he did. Mr. Johnson did the very best he could with what he had to work with. And he was in a tough spot. And the only way to get that defense out was through the defendant. And so I would encourage the court to affirm the judgment of the post-conviction court.
Thank you, General. 4 minutes you have, and it is rebuttal, please.
Thank you. I disagree with the assertion that this is a case with overwhelming evidence until the errors make that undermine the defense case. The evidence that the state was able to present in their own case was that Mr. Hall was arrested in a vehicle that had been stolen somewhere between 19 days and 6 days before he was arrested. It's not a proximate theft. He's in a vehicle that's been stolen for a little while, and that he could have come by very different means. The defense attorney decision was predicated on this belief that the evidence was apparently on a belief that the evidence was overwhelming. The evidence was that truck, chicken, and a set of bolt cutters and a chain, which may have linked him to the Wendy's burglary, although the photos did not show any emblem from Wendy's, and the testimony from the employee was that the chicken was marked. So it's not a case where he had to testify. Mr. Hall had to testify. Mr. Hall was told by his attorney that he had to testify, and that turned out to be the downfall of his case. It allowed the state to resort to what the state resorted to, which was a character attack. They focused the prosecutor's comments in closing argument were she spent a paragraph talking about how Mr. Hall didn't invoked his right to silence when he was talking to the detective. She spoke a lot about how he was a drug user and how he was a criminal, and the fact that then she was also allowed without any objection from Mr. Johnson, to introduce evidence that he had ammunition in the cab of his truck, which can be a really hot button issue. It's something that I'm sure the jury wasn't even voir dired about whether guns or ammunition are something
What was
that's.
the purpose of the photographs?
It was, they were just talking about what was found in the cab of the truck, and I think that it may have been. They showed several pictures from the inside of the truck. There was no argument made about what that ammunition meant, but it was introduced as kind of a discussion of what was found in the inventory of the truck cab during the course of the arrest. So that the state was allowed to make, once he made the decision to testify, which his attorney told him he had to do. I want to come back to something that Judge Dyer said, that an attorney can plant a seed. You can ask that question of the police officer. If you don't get the answer you want, you can wait and just argue that there was not sufficient evidence to show that Mr. Hall was guilty of both of these crimes. At least one of them, you have a really credible argument that he didn't steal the vehicle. And if Mr. Hall had not been put on the stand, his criminal record wouldn't have come in, which was 3 thefts in the past 5 years, felony thefts, I believe. And his incredible story wouldn't have come in. Self-serving statement that the state could have poked holes in other ways, but the state instead chose to violate his right to remain silent by commenting repeatedly on his alleged failure to, his agreed failure to make any statement to the police officer when he was arrested. And I also don't think it's fair to characterize what Mr. Johnson did as intentional. I don't think that if he were carefully walking a line of, I'm going to have him cloak this testimony this way, then he would have been ready to, I think, to jump up and say, and object when the prosecutor asked him this line of questions. And I also don't agree with the characterization that the prosecutor was just kind of stumbled on, or that Mr. Hall jumped on this argument like stink on skunk. I don't agree with that. He first, when the prosecutor asked him whether she said to him, and you gave this information to police on that day, correct? Mr. Hall's response was to say he didn't understand what she was asking. He didn't want to answer the question. And then when there's no objection from the attorney doesn't jump in and save him, then he goes ahead and embraces her line of questioning, but he should have been protected from that by his defense attorney. He should have never been asked those questions. And for all those reasons, we ask you to reverse and remand.
Very good time management. Thank you. Thank you both. We'll stand in recess for the last final case at 4.
All right.
Hold on.